All right, looks like we were close to my birthday before. Reset this. Oh, that's because we had to change ad items. That's right. Okay, here we go. Previous ad item because he decided to go to the dark side and become a prosecutor. So yay. All right, let me go ahead and call this matter and let's see what we have, folks. All right, we're now on the record, and this is Coryell County cause number DC-24 59,903. This is in the interest of Flowers Snider-Child, non-custodial party being Nathaniel Flowers, custodial party being Scalia. Remember, I'm probably mispronouncing your first name, but sorry about that. I'm pretty sure you go by Sky, but anyway, and the last name is Lane. This matters before the court on an original petition to suit affecting parent-child relationship. We've been operating under a temporary order since December of 2024. The court will know for the record that the court did originally appoint ad litem in this matter and had to, again, redo that and appoint Ms. Gustafson as ad litem. The court will now ask the state for an opening to tell the court what the state's requesting we do here today. Then I'll get an opening from the ad litem, and we'll see whether or not this is going to be a final. I don't see anyone in the room here with the last name Flowers at this point. So are we doing this by default? And what are the circumstances for that default? Thank you.
Thank you, Your Honor. Yes, requesting the court to proceed to final order by default. I believe Ms. Gustafson will advise the court that she's made multiple attempts to communicate with Mr. Flowers, and he's not availed himself of her investigation. So, Your Honor, the court already dealt with the financials, so I defer to the court in the ad litem as far as conservatorship, possession, access, and just ask the court to finalize today.
All right, Ms. Gustafson.
Actually, Your Honor, I have spoken with Mr. Flowers several times, and he's not here today, and I'm not sure why he's not. It's my understanding he did know of this hearing. Okay. But I will be asking the court to follow the temporary orders that are in effect and appoint the mother sole managing conservator and Mr. Flowers a possessory conservator. Also, to put into effect the same visitation orders that are there, and I will put on evidence to support that.
All right, thank you very much. All right, then, ma'am, like I say, I don't let pro se litigants make opening statements, but at the end of the testimony, if there's anything else you think I need to know or need to add in your own defense or your own request, you'll be allowed to do so as your own legal rep. But this time, ma'am, I'll ask you to unmute yourself and raise your right hand, please. All right, ma'am, do you solemnly swear or affirm the testimony given in this court today is the truth, the whole truth, and nothing but the truth will help you?
Yes.
All right, you're officially on the oath, ma'am. You can put your hand down, and I'll let the state call you as a witness and ad litem cross-examine. Again, at the end of the hearing, if there's anything else you think I need to know, ma'am, I'll let you know the court at that point. But at this time, Mr. Diamond, you may proceed.
I don't know that I have a whole lot, Your Honor. Maybe if I could hand it over to Ms. Gustafson, I think I'll probably be in agreement with whatever she wants to do.
All right, let's go ahead and do that then. Ms. Gustafson, you're up.
Yes, Miss Lane, can you state your full name for the court?
Galea Elizabeth Lane.
Can you speak up a little bit?
Galea Elizabeth Lane.
And the last time that we were in court, was Mr. Flowers present?
I think so.
And during this court, since December, there was a temporary order in place. Is that right?
Yes.
And under that temporary order, it allowed for visitation. Is that correct?
Yes.
And your daughter, or your son, I apologize, Nakoa is going to be 2 in August. Is that correct?
Yes.
And up until this date, Mr. Flowers, he signed his birth certificate. Is that correct?
Yes.
And there's never been any question that he's the father, correct? And Mr. Flowers has kind of exercised visitation with Nakoa sporadically.
Yes.
And under the visitation order from December, he was able to see Nakoa every first, third, and fifth Saturday from 1 to 5. Is that right?
Yes.
And that visitation was supervised by you or someone that you designated.
Yes.
Now, Mr. Flowers was not always happy about that, because at the time you lived with your mom, and there were a lot of other people that lived in the home. Is that correct?
Yes.
But since that time, you have moved out into your own place, correct?
Yes.
And who lives in that place with you?
Me, my son, and my boyfriend.
And has Mr. Flowers exercised visitation since you've moved to your own place?
No.
Does he know that you have moved residences?
Yes.
When did you tell him?
I could look at the text message, but like 3 days after I moved into this place, and I moved in on the 1st of May.
So on the 1st of May, you moved into an apartment that you only share with your boyfriend and your son.
Yes.
And did you make him aware that your boyfriend would not be present when he exercised visitation?
Yes.
Has he exercised any visitation since March?
No.
Have you spoken to him about that?
Yes.
And what has he told you about not exercising visitation?
He said that he's just not comfortable and he wants to speak to the courts, but then does not show up to court.
And has he said why he's not comfortable visiting at your place?
Because of the people, but I removed that situation and he still refuses.
Did he respond when you told him that you had moved to your own place?
No.
Did he acknowledge that he got your message?
No.
Has he indicated whether or not he thinks that Nakoa is his now, or has he brought that subject up?
He wants the DNA test on Nakawa, but I told him I'm willing, but he has not come, so.
So he did bring up recently that now all of a sudden he wants a DNA test. Is that correct?
Yes.
But this was like the last time you talked to him.
Yes, this was a few days ago.
So when did you speak to him?
The exact date?
Well, you can estimate it. You can't look at your phone right now, but if you
Okay.
can tell me, you said a few days ago.
Yeah, like 3.
So about
Or
3
4.
days ago, you talked to him about court, correct?
Yes.
And at that time, did you ask him why he hadn't been coming to see Nicola?
No, I did not. I told him that if he wanted to do that, that I'm willing.
So about 3 days ago, he told you that he has decided that he doesn't think Nicola is his.
Yes.
Now, is that the first time you've ever heard that from him?
Yes. Well, other than the beginning of our relationship, but he didn't follow through with anything. It was just a heated argument.
And he signed the birth certificate?
Yes.
Now, there was a time when y'all were splitting up that he made threats against you, correct?
Yes.
And he was charged with assault by threat, correct?
Yes.
And it's your understanding that he ended up paying a ticket for that.
Yes.
And he was also charged with terroristic threat.
Yes.
And at this time, you would prefer that you were appointed as a sole managing conservator of your child.
Yes.
Because of his recent inactivity with being around to see Nakoa, do you think it would also be easier for you to have the sole right to make decisions regarding Nakoa and not have to make joint decisions with Mr. Flowers?
Yes.
Do you also feel like it would be in Nakoa's best interest for you not to have to make joint decisions with Mr. Flowers?
Yes.
Are you still concerned that he has a violent nature?
Yes.
Has he made threats to you after those 2
Yes.
situations?
Yes.
When was the last time that he threatened you?
Probably right before we set up the app custody management.
Are you talking about App Close?
Yes.
And did you set that App Close up after the December order?
I believe yes.
So he threatened you right after or right before the December 2024 order.
Right before.
So you still feel that he is a possible threat to you?
Yes, he has previous anger issues, And I've talked to his mom multiple times about getting him in therapy or anything, but he has previously taken medication for this, but is no longer on it.
Now, his mom, have you allowed her to see Nakoa?
Yes.
So even though Mr. Flowers is not exercising the visitation that is set out for him, you've allowed his mom to see Nakoa whenever she's asked.
Yes.
And do you communicate with her?
Yes. Often.
So she has a relationship with Nakoa.
Yes.
So today, are you concerned about him having your address?
I mean, if he would like it, like if that's the only other way that we can do it, but if there's other ways, like we can meet at another location, I would prefer that.
So would you prefer at this point to change the order that's in the temporary order, that you be able to designate, that you not only supervise or designate someone to supervise his access or time, but that you also be able to designate a place or a public place in which your visitation occurs and not have him have knowledge of your address?
Yes.
And are you asking the court at this time to appoint you the sole managing conservator of Nakoa?
Yes.
I'll pass the witness, Your Honor.
All right, thank you very much, Mr. Diamond.
Nothing, Your Honor.
All right, ma'am. When's the last time you seen the child? Okay. And when did you move in with your current with your boyfriend?
May 1st.
All right, so he had 6 weeks almost, and he didn't come down. Anybody see a child anytime during that 6 weeks?
No.
Baby's only going to be 2. No FaceTime, no electronic visits, nothing like that.
No.
Man, what city does his mother live in?
Copperscone.
And what city do you live in?
Copperscone.
All right. Anyway, based on this, again, if he wants the DNA test, he's had the plenty of opportunity to come and ask for one. He hasn't done it. He's not here today. I'm not going to grant that. You know, he's had the time to do that, and if he wants one, he should have been here today to ask the court for one. I probably would have done it. But the bottom line right now is I've already got an order finding that a temporary order finding that he is the father. I'm going to go with that. I'm going to look at naming you sole manager conservators. I'm going to give you the right to name, the right to decide domicile. I'm going to make that right. You don't plan on moving anytime soon, do you, ma'am?
No, sir.
All right. Well, I'll go ahead. I want to restrict you to the central time zone of the state of Texas. So, in other words, as long as you stay in Texas, you okay with me? Okay.
Okay.
Sorry, I can't do that accent very well, even though I lived here my whole life. But anyway, but this time you can't move to El Paso, even though El Paso is a great city. But still, you got to stay here. I'm going to go ahead and what was the child support amount ordered at the temporary hearing, Mr. Diamond?
I'm sorry, Your Honor. Would you mind saying again?
What was the temporary child support amount?
Your Honor, that was,
I think it was 266, was it?
I have 481 on the
Oh,
child
okay.
support, and
Never
then the
mind.
medical was 132.
All right, then was the state requesting retro?
The court addressed retro in the temporary, so I
we
would
did?
ask the court just to make that final.
All right, well, make that final. And ma'am, you get health insurance this time, or was it carried through the father's insurance?
I have my own health insurance.
All right, so I'm ordering you to keep that up in order, and there is a cash medical amount also. Is that correct, Mr. Diamond?
Your Honor, I was not aware that she had a risk for the child, so that would maybe
It's
change things.
It's Medicaid.
Oh, okay. Oh, then that answers it, Your Honor.
Okay. All right, then let's go ahead and again, I'm going to go ahead and mom has the right not to disclose her domicile or address in this matter, but you do have to keep your you have the app close app, correct, ma'am? All right, you'll have to keep that and maintain that until further order of the court. And anytime he wants to contact you via that, I'll let him do it. What's right now? Again, I hadn't looked at the temporary order. What's this? Does he just has visits at your discretion? Is that correct, ma'am? Or on the first, third, and fifth weekends? What visitation package are we looking at this point?
It's the first, third, and fifth Saturdays from 1 to 5, Your Honor.
All right, then. All right, until further order of the court, I'm going to keep that as a visitation, and he has to give you at least 72 hours advance notice through AppClose that he wants his visitation, and you get to pick the spot, ma'am. So again, if you feel comfortable around your house, then he's got to get over it, all right? Because we're not going to inconvenience you because he's uncomfortable. So
Yeah.
We'll see how that works out. But again, looks like he hasn't been doing a lot, and he hasn't done anything in almost 5 months. So, well, we'll see. Anyway, and any court costs in this matter, I'll already be the responsibility of the father, and that he has until December 31st of this year to pay that in full. So is there anything else specifically I need to rule on this one, Mr. Diamond, for you?
I'm sorry, Your Honor. Would the court mind repeating the due date on the?
December 31st this year, 2025?
Yes, Your Honor.
Yeah.
Thank you, Your Honor. No, Your Honor, nothing further.
All right. You think, do you need any, Mr. Dobson?
I think we covered it, Your Honor.
All right, ma'am, do you have any other questions?
No.
All right, ma'am. Good luck to you and yours. And again, I'm not gonna. You don't have his address, but if you do say move to Austin, you need to let him know which city you live in. All right, because again,
Yes.
if he wants his visitation, we'll have to work around that. Okay.
Okay.
But for right now, I'm just gonna give it, and he'll have to come back in and get something above guideline. I'm gonna make a family violence finding. He was actually fined for that, so I'm gonna, and that's why I'm granting non-disclosure and naming you so. All right, and we're off the record. Thank you, Ms. Gustafson.
Mm-hmm.
Thank you, Your Honor. All right, Ms. Gustafson, I'll send you back to Mr. Callaway.
What time
Please.
is it? Oh shit, I gotta go. You see?
Is that Ms. Garcia?
Yes, it was, and I think she had to leave.
I think so too. You gonna miss her plane to Spain this summer? She can't have that.
Oh, and Your Honor,
Yes, sir.
I should make you aware. So I have a meeting from 11:30 to 12. It's a OAG thing. So there'll be other people who will be taking my place doing things. I just
Okay.
figured I'd let you know.
All right. So y'all, I was going to ask you how the changeover go.
Well, it's
I
not
know
just
it's
a
I know
one
it's up
day.
and running, but how's it going?
It's
Yeah.
not easy, but we're working on it, Your Honor.
All right. Hopefully y'all are pass and there's something above that. But yeah, a lot of times y'all the alpha and you just got to go and make it work until it's better. All right. Good luck. Anyway, we'll
Thank
see
you, Your
when we
Honor.
get back, sir. Not a problem.
Oh, and Mr. Diamond,
Sir,
I asked Mr. Gwynn to handle what I was working on. If he needs help, can you talk to him?
of course.
Thank you, sir.
Yeah, you got it. So, Your Honor, I'm going to have a contested case that I'll request the court to hear.
The father is asking to be named joint managing conservators with you. Are you in agreement to that?
No.
And you're asking to be named the sole managing conservator?
Yes.
Why do you feel that you're unable to make decisions together with the father?
Can he start his visitation this Thursday? Where did you have Thursday still in there? Was that, or was it just
every
Friday to
Thursday.
Sunday? And that can start this week, right? 6 to 8?
Yeah, that's what I was encouraging you to do at the very least.
Starting with this tense exchange between Miss Trammell and Mr. Hall, she demands sole custody, saying they can't even talk, while he fights for joint rights, claiming he's already spent thousands on the children.
All right, Irvin Hall and Nicole Trammell, please unmute and turn on your camera. All right, do you both swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. All right, Ms. Satterfield, go ahead.
Thank you, Your Honor. The state would like the court to take judicial notice that both parties are here, and a copy of the state's petition was sent to them via email.
So noted.
Thank you. We have a partial agreement. I will read the agreed portions and then take testimony on conservatorship and child support, which are the contested issues. Parties are in agreement that when 3 children were born, the father signed an acknowledgement of paternity, and the 4th child was born during the marriage. Parties are in agreement that there's been no acts of family violence in the last 2 years. Parties are in agreement to a mutual non-disclosure of their address. Parties are in agreement to a state standard possession with an exchange location of the Duncanville Police Station at 203 East Wheatland Road, Duncanville, Texas, 75116. Parties are in agreement to no geographic restriction. Father's gross income is $4,767 with a net resource of $3,915. Parties are in agreement for cash medical to be paid at $85 beginning July 1st, 2025. The children are on the government medical plan. Parties are in agreement to no retroactive child support and court costs as billed. Ms. Trammell, can you please state your full name?
Nicole Trammell.
Name and ages of your children.
Noah Hall, 15. Jacob Hall, he's 11. Irvin Hall, the fourth, he's 8. And Elijah Hall is 1.
Ma'am, did you hear the agreed portions that I read earlier?
Yes.
Are those still your agreements?
Just for to be paid?
Everything I read earlier, are those still your agreements?
Yes.
Do you believe they're in the best interest of your children?
Yes.
And are you asking the court to accept those portions?
Yes.
And the non-disclosure is only of your address, correct?
Correct.
It's on the father's income. The state's asking for child support to be set at $1,370 beginning July 1st, 2025. Are you in agreement to that?
Yes.
And you understand that was based on guidelines, correct?
Yes.
The father is asking to be named joint managing conservators with you. Are you in agreement to that?
No.
And you're asking to be named the sole managing conservator?
Yes.
Why do you feel that you're unable to make decisions together with the father?
Because he doesn't cooperate. I can't even to him. He's non-cooperative.
So you two are not able to amicably discuss matters pertaining to your children?
No. Not at all. I have a disabled son. I can't even tell him about anything that's going on with him.
Okay. I pass the witness, Your Honor.
All right.
Mr. Hall, can you please state your full name?
Irvin Hall III.
Mr. Hall, did you hear the earlier portions that I read as an agreement?
Yes, I did.
Are those portions still your agreement?
Yes, everything is except $1,000, $1,300. Yes.
Are you asking the court to accept the earlier portions that I read?
Yes.
And do you believe they're in your children's best interests?
Yes.
Sir, the state is asking for guideline child support to be set at $1,370 beginning July 1st, 2025. Are you in agreement with that?
No.
Can you explain why you don't want to pay guideline child support?
Yes. I have documented records showing that in 2024, during our separation, I've given Ms. Trammell child support and support for my children.
So we're not
Uh,
asking for retroactive child support. This would be future child support starting on July 1st, 2025, going forward, not arrears. No, there are no arrears.
Well, also, I apologize for that. Moving forward, I'm able to put my children in social development, extracurricular activities, and social development programs as far as STEM programs, athletic programs. My son is getting ready to go to NASA Space University that I paid for. And so
So
I
you're
do not
asking,
believe. Go
you're
ahead.
asking for child support to be lowered because you pay for extracurricular activities and other outside programs that you pay for?
As well as clothing, other resources, and things and items that they need as well, because I cannot trust her with the money anymore. She doesn't need put that towards them.
So he's basically saying, I will support my kids, just not through her. That tells you a lot about how broken the co-parenting relationship is. Maybe she spent child support on herself in the past. New hair, new clothes, who knows? Whatever it is, he clearly doesn't believe she's putting the kids first. But then, you just have to pay child support to her. And this time, she should be monitored closely at least. It's that easy. What do you think?
So I can't trust her with money.
How much are you asking for child support to be set at?
$400 a month. I give my sons $100 a week.
So you want child support set at $400 a month for all 4 children?
Yep.
Court costs are billed to you today. Are you in agreement?
No.
Are you asking the court to waive court costs today?
Yes.
And can you explain why?
I'm in the process of moving. I don't have the money. I do give my money to my children as well. So I don't have the money for court costs.
Okay. I pass the witness, Your Honor.
All right, the parts y'all agreed to at the beginning, those are all fine. I don't understand what your argument is, Mr. Hall. You have to understand that kids do not have pay bills. They don't pay the house or a rent bill. They don't pay for electricity or water. They don't pay for groceries. They don't pay for gas. So giving the children money directly is a gift. They don't pay those bills. That's not money that's going to them. And the whole amount of child support isn't going to go to them. It's so they have a place to live primarily, and they can enjoy the things like that I just mentioned. They get in the car, they go have a place to live, and things like that. That's money that the mother, who's the custodial parent, will decide how to use that money. It's not about you trusting her with money. It's money going into the household for your 4 kids. That's not cheap for 4 kids to pay all those bills. I'm sure they eat a lot and things like that. And so that's how this works. It's not how child support works. It's not child support for the children. It's child support to maintain the children. If there's any money left over, then the custodial parent, then you can use it to maybe give them an allowance or buy extra things for them. But that's up to them to decide. You don't get to decide for the custodial parents. They make those. So your child support is going to be $1,370.
I don't get to respond to
If
that.
you want to pay for extra stuff that's called extracurricular, that's up to you. I'm not obligating you to do that. If you need to cut back on some of that, that's fine too. That's up to you. Sometimes we have to make decisions as parents and say no. So that's up to you, but I'm not giving you credit for any of the extracurricular activities that are not a part of this child support. So you have to pay this first before you do anything else. Any money you give to your kids directly, any clothes you buy for them directly, anything like that does not
Yeah,
count as
she's
child
not
support.
mentally fit to
Excuse
be a
me, sir,
mother.
I'm talking. I don't know if you know how the court works, but I'm the judge. I decide your case. So this is my ruling. You need to listen to my ruling so you understand. That is not how it works. Child support is going to be $1,370 a month. Since y'all don't communicate, sounds very simple. Y'all don't have agreed to a lot of stuff that kind of points towards y'all being so managing because y'all can't even have each other's addresses and have to have an exchange location at a police station. Well, there's no reason for me to even talk about joint managing because that tells me right off just from the very beginning y'all don't communicate very well. So I'm appointing Ms. Trammell as the sole managing conservator. You will be paying court costs. Dallas County will be sending you a bill for that, Mr. Hall. That's the way this works. When you file lawsuit gets filed, there are court costs. You're the one that's going to have to pay that. All right. The Attorney General's office is going to put that all in writing for me to sign. That'll be the court order. Y'all must follow. They'll send out a withholding order. And so make sure that y'all are all following the order and that what you're supposed to be doing, even if you don't agree. All right. Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Now, this one centers Ms. Mays and Mr. Hernandez. The mother is opposing joint custody, demanding supervised visits once a month, while he just wants a chance to be in his daughter's life.
All right, Delfino Hernandez and Tavana Mays, please unmute and turn on your cameras.
Hello?
You need to find a quiet room, Ms. Mays.
Good morning.
You need to find a quiet room.
Sorry, can you hear me?
I don't think either one of you are listening to me. Mr. Hernandez, you
Yeah,
need to turn
I'm
on your
listening to
video.
you.
Ms. Mays, you need to find a quiet place.
I apologize. I'm trying to get my daughter situated right now.
Do you want me to come back to you later on then?
No, I'm ready.
Is she in another room?
Yes.
Okay, Mr. Hernandez, still waiting on you to turn on your camera.
How do you do this? Sorry, I'm trying to. There it goes.
All right, do you both swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. All right, I'm noting that both are present and have made an appearance. Go ahead and proceed.
Thank you, Your Honor. We're here on a suit affecting the parent-child relationship. We have a partial agreement. I'll read the agreed portions and then we'll take testimony on the contested issues. Parties are in agreement that there's been no family violence between them in the last 2 years. The child is under the mother's health and dental insurance through her employer at a cost of $800 for 4 people. Parties are in agreement that the father has one other minor child. No geographic restriction. Father's gross income is $3,466.67 with net income of $2,955.34. Father is in agreement to pay child support in the amount of $495 a month beginning July 1st, 2025. Cash medical reimbursed to the mother for $115 a month beginning July 1st, 2025. Dental insurance of $12 a month beginning July 1st, 2025. Parties are in agreement for retroactive child support in the amount of $17,820.48 as of June 1st, 2025, to be repaid at $139 a month, beginning July 1st, 2025. Court costs is billed to the father. The rest are contested, and I will take testimony. Ms. Mays, can you please state your full name?
Savannah Mays.
Name and age of your daughter?
Choma Giselle Mays Hernandez, and her age is 2. She'll be 3 in July.
Ma'am, did you just hear the terms that I read?
I did.
Are those parts your agreement? Do you believe they're in your child's best interests?
Yes.
Are you asking the court to accept those terms?
Yes.
Now let's talk about the parts that there's no agreement, okay?
Okay.
You understand the father's asking to be named managing conservator,
Okay.
and you're not in agreement with that?
No.
And can you state why you're not in agreement to be named joint managing conservators with Mr. Hernandez?
Number one, because I've been managing my child since she was born, with no input from him. Like I said, we don't communicate well at all. We don't work together well. There's a lot of conflict between us, and so I just believe for the best interest of her, and to get things done, I would like to just remain the sole. And there's no difference, custody and like visitation. It doesn't regard visitation. That's usually what he's concerned most about, is the visitation. So,
And is it true that Mr. Hernandez lives in,
to my knowledge, yes.
and that's
That's
over
what I-
100 miles, correct?
Yes.
Okay. You understand that the father is requesting to have the state standard possession for over 100 miles, which is 1 weekend a month?
Okay.
If you can answer yes or no, so we can be clear.
Yes.
Okay. And you are not in agreement with him to have the state standard possession, is that correct?
No.
You're asking for the father to have supervised visitation?
Yes.
And you're asking for him to have supervised visitation Saturdays 2 to 6 and Sundays 2 to 6 once a month, is that correct?
No, Saturdays was the 12 to 8 was fine. And then Sundays 2 to 6.
You're asking for one Saturday a month from 12 to 8 and then the following Sunday from 2 to 6.
Yes.
Has there been, you stated there's been no acts of you, correct?
No.
And has there been acts of family violence against your child?
No.
Can you state why you want Mr. Hernandez to have supervised visits?
So I just feel more comfortable with another party being present during visitation at all times due to safety precautions for my daughter. As I said before, he's not been physically stable, nor mentally stable since I've known him. I'm not even sure if he is, living on his own. I don't know anything about his living situation. As far as I've known him, he's always lived with someone else, which I'm not comfortable with that. And also, there's just been, conflict, and the things that I know about him, he's kind of a manipulative person, and he's made comments about taking my daughter to San Antonio, basically without my permission. And so just those type of things I don't like to joke about or play when it comes to my child. And so I just feel more comfortable if somebody else is present to make sure that, she returns to me after the visitation.
Now, she's throwing a lot of red flags about him, but none of them are backed by an actual incident. That's where it gets tricky. It sounds like she's emotionally tied up in the past and maybe projecting that into his ability to parent.
And the supervised visits would be by your mother?
If possible, I'm not sure if she'd be willing to do that. I had conflict issues in the past, so I'm not sure. I would have to speak to her about that.
Who are you wanting to do the visitation if you haven't?
So the only other person that I could utilize would be like I said, a paid supervised personnel.
Okay. You're wanting a non-disclosure of your address, is that correct?
That's correct.
And you're wanting an exchange location at the Kroger at 1060 North Main Street, Euless, Texas 76039.
Yes.
And You are okay with the father having your phone number, correct?
That's fine.
Okay. Pass the witness, Your Honor.
All right, call your next witness.
Mr. Hernandez, can you please state your full name?
Delfino Sebastian Hernandez.
Sir, earlier I read some terms as an agreement. Were those terms still your agreement today?
Yes.
Do you believe they're in the best interest of your child? You nodded. Can you please say yes or no?
Oh, I said yes. Sorry. I don't know if you
Okay,
can.
no problem. Are you asking the court to accept those earlier terms?
Yes.
Okay, now let's talk about the parts that we didn't agree to. Even though you live 100 miles in San Antonio, you're asking to be named joint managing conservators with the mother.
Yes.
Do you believe that you can make decisions amicably with the mother in your child's best interest?
Being able to cooperate and make decisions with her.
Yes.
I would like to. I don't have an issue with that at all.
Are
Not
you
me,
able
not
to
on my side.
communicate with her now?
No, she has had me blocked since last February.
Okay. You heard that the mother's wanting a non-disclosure of her address,
I heard.
and you're not in agreement with that?
No, I would like to send my daughter gifts.
So you're asking to be made aware of the address where your child resides, is that correct?
Yeah, I don't want to be alienated anymore.
Okay.
I would like to send at least some gifts and things to my daughter.
Okay. Are you in agreement for the supervised visits one Saturday from 12
No,
to 8 p.m.?
no.
And so you're asking for the state standard possession, is that correct?
Yes,
The 1 weekend a
just
month.
because. Yes, I have been at my same address for the last few years. You can go look up my employment history of my previous employer. Still there. Still the address I use.
Okay.
Um,
So are you
but I
in
don't know what.
agreement? I'm sorry, go ahead.
No, I would just. I wasn't aware of any of her accusations ever, to be honest. And her husband tried to threaten me in public at a McDonald's. He's always made threats. I have a threat, a voice threat that she's aware of on my phone, a voice clip. I could turn that in if I have to separately for another case. But we got along just fine until she met her new person and her new husband. And ever since her new husband has came into the picture, he has been the issue, and he is the one that had me blocked.
Are you in agreement for the exchange location that's located at, is that the Kroger on 1060 North Main Street, Euless, Texas, 76039?
No,
You're wanting to pick up the child at the mother's address, is that correct?
as I used to, yeah.
And you're
If we
wanting to
gotta
drop off the child after visitation at the mother's address, is that correct?
correct, if we gotta take lie
Okay.
detector tests, that's like I used to pick her up and drop her off. I used to hang out there at her apartment with her, with my daughter.
To be fair, when people remarry, they naturally start protecting their new home life, but that can unintentionally cut out the other parents. Sometimes the new partner feels like co-parenting is keeping their ex so close. It becomes less about safety and more about territory. This is not fair. She shouldn't make it. This is my child, not our child case. What do you guys think?
All right, I pass the witness, Your Honor.
Just one quick question, Mr. Hernandez. Before February, you had a relationship with your child and you visited.
I would send gifts through Cash App. I would send money, and she would
I didn't
still
ask
make
about
me wait.
gifts. I didn't ask about gifts.
No, yeah, no. I had contact. I had contact with her, text, phone calls.
You visited personally though as well?
I would spend the night in her apartment there with her family, letting me so I can hang out with my daughter.
All right. The parts y'all agreed to at the beginning, those are all fine. Those will be part of the court order. Being that y'all don't live near each other, I'll grant mother's request for the sole managed conservatorship. It'd be pretty hard to work together to make decisions if y'all don't live in the same city. San Antonio is pretty far away for that, so that's the main reason why I'm doing sole managing. Y'all reported there's been no family violence, and so I'm not granting your non-disclosure request, Ms. Mays. Both of y'all are required and obligated by the court order to notify the other party where you live. Anytime that either one of you move, you need to notify the other party where you move to. That's part of court orders here. There's no reason for us to do anything different. Y'all have to figure out a way to work together. Y'all made this child together, and so y'all are gonna. There's only 3 people involved, not other people. I understand that when the child is with you, that you will have to make sure your child is safe from other people.
Exactly. So do better, please.
And that's an assumption that both of y'all should have when the child is in the other parent's care. There's no reason for supervised visitation. I know visitation will be difficult as it is with Mr. Hernandez living in San Antonio, so it's already going to be pretty hard. It's in the child's best interest, even if it isn't in your parents' best interest, for the child to visit with father as much as possible. You may not like it, but the child will. So it's kind of more of a child's right to visit with both of you, and they do want to visit with both of you, even if you have a different opinion. So there's no reason for supervised visits. We're going to do standard visitation, exchanges at mother's address. Again, y'all reported no family violence issues. There's no reason for Mr. Hernandez to come into your residence. He's going to pick up at the doorstep, and he can go to San Antonio if he likes, if he has enough time. That's not illegal. There's nothing wrong with that. He lives in San Antonio. He's going to go wherever he lives. That's not something that's what happens. Obviously, if he only has a weekend, that may not be practical. Maybe Mr. Hernandez will wind up staying in Dallas for the weekends when we do the weekends. But that's up to him. That's his choice. If he wants to pick up the child and on Friday night and take the child all the way to San Antonio and then drive back by Sunday night, that's up to him. He has that choice. He's the father of this child. So exchanges at mother's address, not at this exchange location. There's no need for that. There's been no family violence. If y'all agree to something different on the visitation, I definitely recommend that. But that takes two people agreeing to it, not just one person telling the other person what they're going to do. You're going to have to follow my court orders even if you don't agree with them, because that's what's been court ordered. All right, so very important here. There hasn't been a lot of visitation recently for really no reason at all. So I want to make sure we're clear. It's the summer. There are two plans for visitation. One, if you live within 100 miles, you get every other weekend, and you get 30 days in the summer. If you live over 100 miles away, Mr. Hernandez gets to pick a weekend once per month to do visitation. He needs to let you know, Ms. Mays, when that will be. Hopefully as soon as possible, maybe at the latest by Thursday of that weekend, so that you can make plans. But that he will have one weekend a month. Since it's the summer, it's going to be extended visitation to 42 days because so we're losing some visits because of the distance. Mr. Hernandez has 42 days of visitation in the summer instead of the 30 days. So since the orders will read that he has to give you notice by April 1st of what 42 days he wants. Obviously, we're in June, so that's not going to happen for this year. In the future, if he wants to specify different dates, then he can. But the default order reads that if he never gives you notice, he gets visitation from June 15th through July 27th. So just make sure y'all understand that he will have the child from June 15th to July 27th this year, like in a few days. During that month, of course, the child support begins July 1st. So even though you have possession in July, you still got to pay child support in July. So your child support will be 12 months of the year, not just 11 months of the year. So I just want to make sure you understand that as well, Mr. Hernandez, that you still have to pay child support even though you have the child that month. All right. Hopefully y'all can figure things out here for the future. You need to make sure that other people are not influencing you or trying to make you do something different. Remember, again, there's only 3 of you involved in this case. 2 of you chose to have this child. Only you 2 are the ones that make decisions, not other people, not new spouses or new boyfriends or girlfriends. They don't matter. Their opinion does not matter. You have to decide. And y'all 2 decided. Y'all were the only 2 people that are present, and you're the only 2 people that should be making those decisions. If y'all cannot reach an agreement on issues, read your court order. It'll probably answer the questions on those, and you must follow that even if you don't agree with my decision. All right, the Attorney General's office will put that in writing and email you a copy. Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Your Honor.
Thank you.
We're done, Ms. Mays. Follow my
Your
orders.
Honor.
Follow my orders.
I didn't get
Follow
to
my
speak.
orders. Follow my orders.
To speak to you, Your Honor.
You did. You testified already. You answered like questions that Ms. Few asked you, and you testified, and that's how I made a decision.
But on my testimony, I said that he was a drug user, so I'm not sure how it's allowed for my child to be in custody of someone
We're
who's
done,
using
Ms.
drugs.
Mays. We're done. You didn't prove your case. You did not prove your case.
Honestly, it's crazy how anyone can actually choose to have baby for a man, then turn around claiming he's into drugs just to restrict access. Seriously? With no evidence? All that sounds like excuse to limit access to their child, please. Finally, this last case centers on Mr. Norris, who says he wants joint custody and more time with his son, but hasn't seen his child in over a year.
Willie Norris and Jessica Hamilton, please unmute and turn on your cameras. Do both of you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. I've noted they're both present.
Thank you, Your Honor. We're here on a suit affecting the parent-child relationship. We have a partial agreement, and I will read the agreed portions. Parties are in agreement that the child is on the government medical plan. Parties are in agreement for the father to pay child support in the amount of $852, and that's given the father credit for 2 other children. Parties are in agreement for cash medical to be set at $206, and this is to start July 1st, 2025. Parties are in agreement to a geographic restriction to the Dallas and contiguous counties. I'm going to take testimony on the rest. Ms. Hamilton, can you please state your full name?
Jessica Michelle Hamilton.
Name and age of your child or children?
I'm Kyron True Norris-Hamilton, and he is 4 years old.
Ma'am, did you hear the terms that I just read?
Yes, ma'am.
Are they your agreements?
Yes, ma'am.
Do you believe they're in the best interest of your child?
I do.
And are you asking the court to accept those terms?
Yes, ma'am. That's the child support and then the cities we live in, correct?
And the medical support?
Yes, ma'am. I agree.
And has there been acts of family violence between you and Mr. Norris III in the last 2 years?
Not within the past 2 years.
Do you have any safety concerns with him having your address or phone number through our court order today?
Well, he already knows all of that information. I'm still living at the same apartment whenever he would come over at times.
So if you moved today or got a new place or a new phone number, would you still be comfortable if he knew your new address or your new phone number?
My new phone number, yes, preferably not my address.
And why are you wanting a non-disclosure of your address?
I feel like it's been some years since me and him have had good communication with each other. At this point, it might change in the future, maybe me not having that, but as of right now, we don't know each other anymore. And the person that I know of, there was violence that was involved.
There was violence in the past, but not in the last 2 years.
Yeah, but no, not in the past 2 years, correct. But no, we just don't know each other anymore. And so I'd like to be more comfortable with that.
Okay. Are you in agreement for the father? Are you in agreement to be named joint managing conservators with the father?
No, I was requesting sole conservatorship.
And can you explain why you don't feel that you can make decisions together with Mr. Norris III?
I've just been the only one. I'm sorry, I'm a little shaky. I'm just a little nervous about this, but I'm just trying to say this the right way. And I really appreciate it if he didn't interfere with when I'm talking. But I've just been the only one making decisions as to where he's gone to daycare, as to where he's gone to school, as to doctor's visits, dental visits. And so I'm just requesting that because in the past we had agreed on those. So I'm just still wanting to continue that role for my son.
Are you able to communicate with him? Are you guys able to communicate amicably?
I would like to say I want to get to that point. We haven't spoken to each other in quite some time.
Are you still requesting that the court order you to communicate through AppClose?
In the beginning, I would like to do that. I don't know if that can
Mr.
change
Norris, I
once
need you to-
our relationship gets more comfortable with each other.
I'm sorry, no, I thought you were done in the night. Mr. Norris, stop making comments while she's talking, please. All right, go ahead, Ms. Hamilton.
Thank you. You and Mr. Norris ceased to live together September 2021, is that correct?
Yes, ma'am.
And during that period of time, is it your testimony that he's only given $150?
I mean, I haven't sat down to do the math on it, but I know that he's bought clothes for him before, maybe $7,500. He's bought diapers for him a couple of times, but that's really the only thing he's contributed to since True's been here with us.
So you're wanting to give him a credit towards the retroactive support. You're willing to give him credit of $150?
Yes, ma'am.
Okay. The state's calculating retroactive child support with the credit to be $11,475 to be repaid at $100 a month beginning July 1st, 2025. Are you in agreement with that?
Yes, ma'am.
Pass the witness, Your Honor.
Call your next witness.
Mr. Norris III, can you please state your full name?
Yes, Mr. Willie Jean Norris III.
Sir, earlier I read some agreed terms. Are those terms still your agreement?
For the child support. Yes, ma'am.
Do you believe they're in your child's best interest?
I don't, but I'm agreeing. I'm agreeing to pay child support to my kid so I can actually see my kid as well.
But you're agreeing to those terms.
Of course.
And you're asking the court to accept those terms as well.
Of course. Yes, ma'am.
Sir, has there been family violence in the last 2 years between you and Miss Hamilton?
No, ma'am.
Okay. Are you asking to be named joint managing conservators with Miss Hamilton?
I am.
Have you been communicating amicably with her?
I have attempted as much as I can. Ms. Hamilton has a case of wanting to work together when it's due for her. As far as setting up daycares, I set up daycares for the kid as well. Provided housing as well. So for me, I want to provide support for my kid. And I like to do it as managing conservatives as a mom and dad, not just one person dictating everything for the kid, in which that's the reason why we're here today.
Are you in agreement for the state standard possession, which is the first, third, and fifth weekends of the month?
Yes, I actually asked for extended standard due to the absence of True being in not only my life, but also his brothers and sisters who he has a relationship with and who he knows. True knows his dad and his mom. And yes, I would like for us to have extended, but I'm willing to meet in the middle with Miss Hamilton and do standard to begin everything for the best interest of True.
Are you in agreement to communicate with Miss Hamilton using the app Close?
And I just want to apologize to Your Honor. I don't know what that is, and that's why I wrote down. I tried to understand what that was, but I don't even know what that is, to be honest with you. So I don't know how to answer that question.
It's a communication app where you guys can message each other.
Right, but I don't mind doing that, but Ms. Hamilton and I have communicated via text messages and phone call. The last time that I did see her, she arrived and popped up, unbeknownst. And so if she has an issue with communicating through via text messages and phone calls, then how is it easy for her to show up and communicate in person? So I don't mind communicating in person or via text, whatever the healthiest for the kid. At this point, it's just the best thing for us.
The state's calculated retroactive child support, and have you given the mother financial assistance since you separated in September 2021?
Yes, ma'am, I have. And as I stated, I can send all documentation over for what I have provided. I've also provided support for True. This is for True. I've provided support greater than $150. Yes, ma'am.
Okay. Sir, how much would you say you've given?
The lady that I talked to before, I have estimated just from Cash App $1,400, not including the cash that she's denied in person.
So you're asking for credit
support, right? She's denied support of payment and also insurance, is what I'm saying.
Sir, please be very brief with your answers. You're wanting a credit of $1,400, is that correct?
That I have presented today, but there's more. Again, I wanted to do amendment for that as well because I have other documentation to prove that. I provided more than what
we're doing a final order today, Mr. Norris. So I need you to tell me the full number that you're asking for. I'm not saying I'm going to grant it. I don't know yet. But I need to know the full number because we're not going to come back at a later date to change anything. I'm going to make a final decision today.
Right. The full number that she asked me for was between September of us actually separating or her moving out up until the point of last year. And that's what I came up with, 14, I believe, 82. And that's just in cash out. Now, as far as cash, there was a payment of cash through $500 that was given while I was incarcerated of $500. And so we want to add that. That's $1,900 that she's gotten from me just in those payments. And again, this is just payments for truth.
Sir, are you asking for, you said 1,400 and now you're saying 1,900.
Well, he wants a final. He said for a final. So there's an extra $500 that I just actually looked up in text message that was sent to her. $500 from Zachary Wagner. And so
Okay.
that's 1,400 plus 500.
Okay, if giving you a credit of $1,900, are you in agreement
I
for
am.
a retroactive child support judgment in the amount of $9,570?
Yes, ma'am.
Okay. Are you in agreement to repay that amount at $100 a month starting July 1st, 2025
Yes, ma'am,
until
I am.
you've repaid that? And court costs are billed to you today. Are you in agreement?
I would like to split those as well.
Your Honor, I'd like to pass this witness and recall Ms. Hamilton.
Okay.
Thank you. Ms. Hamilton, are you in agreement to the father having the state standard possession, which is the first, third, and fifth weekends of the month from Friday, 6 p.m. to Sunday, 6 p.m.?
Yes, I would like to add in supervised visitation in the beginning of that, or however I'm just word this the best way I know how. If we can start out with supervised visitations and then move into the standard visitation, I would appreciate that for true.
Has there been family violence with the child?
Not with the child, but he's just, True's never been around his father without my presence. And so I was hoping to just kind of do a slow transition for Kyron, just because he's never been without me. And so I'm just trying to keep the best interest for him, because he around his father in a long time.
I get things didn't work out between them, but let's be honest, there is no evidence that he is a danger to their child. It feels more like fear of change than actual risk. And yes, kids are absolutely adjust, but they also pick up on tension between parents. If you focused more on helping them rebuild their bond instead of holding back out of discomfort, it could make a difference. What do you think?
Okay, I'm sorry, go ahead.
I was going to say, he did mention about me showing up. There were messages that of him telling me where he was at, which is how I was able to get there. And it was last Father's Day.
Let's just talk about the visitations. You want to start off like a graduated visitation and then go into standard visitation?
Yes, ma'am.
Okay, you want supervised visits for a couple of weekends?
Maybe a month or two, I'm not sure.
Okay, so would you want supervised visits, let's say 12 to 4 for a month?
Sure. Yes, ma'am.
Okay, do you have a competent adult to do supervising, not you?
Yes, ma'am.
And who would this person be?
His godparents, Abel and Dacia Longoria.
Abel and Dacia Longoria?
Yes, ma'am. Yes, ma'am. Dacia Longoria.
Okay, so if we did Saturdays 12 to 4 for a month and then then the standard?
Yes, I just would however long, if kind of asking for advice on this at this point, whatever is going to be a smooth transition for True. Like I said, he hasn't been with his dad, in a year. He hasn't seen his father in a year. And so I just want it to be good for him, whatever time that's going to take.
Okay.
I guess I'm asking for advice on that part.
So I'm understanding 12-4 on Saturday, supervised by Abel and Dacia, Abel or Dacia Longoria, who are the father's godparents.
They're True's godparents.
The child's godparents.
Yes, ma'am.
Okay.
Do both of them have to be present, or could it just be Abel or just Dacia, or do they have to be together?
I said Abel or Dacia.
Oh, okay. Okay, thank you.
Okay.
Mr. Norris, turn on your camera. Never told you to turn it off.
It turned off by itself. I never turned it off.
Okay, well, I've been asking you to turn it on.
It's asking me to my video.
Stop.
It's asking me to restart my video.
Yeah, because you turned it off.
Okay.
I've never touched anything.
Okay, I'd like to pass the witness, Your Honor.
Okay, I got a couple questions I need some answers to because I'm not sure I understand. So, Ms. Hamilton, when was the last time that Mr. Norris visited with the child?
It was Father's Day of last year.
Okay, and how old is the child now?
4.
4. Okay, so I guess it's been about a year, but why would we not have Mr. Norris visit on a regular basis if he? It's not a burn or anything like that. Obviously, a young child, but um, besides there not being visitation for the last year, is there some other reason why he can't have visitation without being supervised?
I think it would just be more of a learning curve for True, because he's been in his life. Oh, I think I just messed something up. I'm sorry. Hold on one second. I don't know what I just did. Sorry, I hit my keyboard. He just hasn't been in his life consistently, and I just don't want True to just jump into a new home, a new family kind of a thing without just kind of slowly easing into it. Yes, his father's not a stranger. I mean, he knows like who he is, but in terms of like just changing into a new living situation, I would just like True to kind of adapt to his dad again, and but consistently. It was never consistent before. And like, True would get upset and cry. And it's hard to explain to a 2 and 3 and 4-year-old. Well, not 4, he hasn't seen him since 4, but to a 3-year-old, why daddy's going to be gone for a long time. And like, it was hard for him. It was hard for me. It was hard for both of us, but more so, I think, for him.
Okay, well, I think Mr. Norris is saying he wants to visit on a regular basis. For
Hmm.
whatever reason, y'all have had a disagreement, I guess the last year or whatever. I don't want to go into all of that as to why or anything because I can't turn back time here, but I'm hoping Mr. Norris wants to visit. I'm just don't need to be supervised. We
I
have a
guess just
4-year-old. Hold on. We have a 4-year-old, and if the child's not in school yet, the child be in school in August. You're gonna trust some stranger and a whole bunch of strangers at the school to take your kid from 8 to 3 every day for 5 days a week.
It's refreshing to see a case where the judge doesn't have to referee drama. I mean, supervised visit sounds like a punishment to the father. Thankfully, the judge isn't letting that happen.
And we're not making them do supervised visitation. So we're talking about Mr. Norris being the father of the child. I'm assuming the child knows who their father is, even if they haven't visited in the last year. So I mean, again, it's a young child, but not a really young child. I mean, it's 4-year-old, not a 1-year-old. So I guess I'm not understanding why we need to have Mr. Norris supervised, other than y'all two have had your personal issues with each other.
right. No, and I understand. And I know supervised visitation can have like, I don't know, it frowned upon. I don't want this to be a bad thing. I'm just kind of thinking like of True and like with his dad being consistent in his life again. And I'm all for that. I completely want them to have a relationship. I guess it was brought to my attention to maybe mention it. I looked into it just to have a slower or smoother transition for True. But I never meant for it to be a bad thing. I just was like, oh, that sounds like a good idea. I guess we can try that and then go into the standard, visitation. But I mean, you have a good point about the school, so I have to agree with you on that. I feel like it's a little different.
I understand, but
Yeah.
I mean, it's even to me. I guess I look at it from the other perspective. It's better that a parent visit than a teacher. Obviously, I want kids to do well in school, but it's different when it's a parent. So uh, that's even more important that they be alone some of the time with visits.
Yeah,
Um, okay,
understood.
so
Okay.
one more question, I guess I think is when y'all did visitation exchanges before, did you visit? Did y'all do the exchanges at your residence, or did y'all meet somewhere? And what do we need to do for the future for visitation exchanges, assuming we're not doing the supervised visits?
We actually, I'm trying to think. We would always kind of meet at a Publix together. It's like I never like gave True to him or him get like it was never an exchange. Would just be together in a public area.
Okay, but we're
So
doing visitation now, so what are we wanting to do
right.
now?
So
Normally,
for
people
now,
come to your residence to pick up the child. I know you have some reservations. I want to make sure you're there, of course, but are you asking for him? I mean, like normally he would come to your residence. Are you asking for that? Or number two, if you want to meet somewhere, I need a specific place that we can put in the court order that y'all can meet at.
right. He's been here before, so I would be fine with, having the exchange done here.
Okay. Are there any, Ms. Hamilton, are there any convictions for domestic violence in the past?
It has happened, but there has been no convictions. You mean like from me to with his? I meant like with me to his father. Is that what you were asking?
You're alleging, I guess, there was some family violence with Mr. Norris a long time ago. So I'm
Yeah,
trying to
there has
understand if
been.
there was any convictions where Mr. Norris was convicted of something.
Not with me, with other people. Yes.
Okay, but not
Yeah,
you.
but
Only
yeah,
one
not with
last-
me. Right. Yeah.
Okay.
Yes, sir. Sorry.
All right. Then let me go ahead and enter my ruling then here. So we're agreeing the child support is 852. We're doing government medical for insurance. Medical support is 206. I'm making a find there's been no family violence within the last 2 years. Obviously, there has been some communication issues. Is just that, for example, y'all haven't done much in the last year as far as communicating or visiting or figuring out what you're supposed to have done. So um, there's obviously some communication issues we have. They may be both sided, I don't know, but we got to work on that for the future. So I'm appointing Miss Hamilton as the sole manager conservator so that she can make decisions. You still have rights, Mr. Norris, that are in there as far as being a possessory conservator, but it just kind of giving her a little more control on the decision-making stuff. But you still have access to talk to teachers and doctors just as well as she does. So if you still have access to information. Based on what I've heard today, I'm not granting a non-disclosure request. So y'all are both to notify each other where you live. It'll be included in the court order. Anytime either one of you move, you need to notify the other person in writing by email, text, or letter, telling them your new address. I don't know. I guess I'm not sure if we need app close. I'm going to put it in the court order, but y'all can decide after today if you want to continue with that. The app close is an app. It's a tool that we can use when people don't communicate very well. People like to cuss each other out, or they want to threaten the other party, things like that. Or they don't like the language of the other parent's language when they talk about the child or this or that. A lot of different reasons. What AppClose does is a tool where it kind of can record your conversation, like your text conversation. And so that if we have to use that in the future at a later court date, then you can print it out. It's a little easier to print out than like a text message. Um, so I'm gonna order it, but y'all kind of need to decide which is better for y'all. I want y'all to figure out a better way to communicate. We're kind of starting over in a way today. I know y'all have had a problem in the last year at least. So y'all got to kind of start over now on communication. I know maybe y'all have had some issues. I have not made a determination. There's been family violence, but obviously y'all have had some relationship issues. And so hopefully after today, we can just focus only on the child and have better communication only about the child. So I'll leave that up to you. I'm going to order it that you add it. If y'all wind up not doing it, I'm not going to be monitoring you to see whether you do it or not. But if y'all both feel comfortable doing it that way, then that probably should be the better way to do it. If y'all wind up where text is easier, then I'll leave that to you. As far as the back child support, I'm going to give Mr. Norris credit for the amounts he's alleged. So the judgment after his credit is $9,570 to be paid at $100 a month until paid in full. Being that there hasn't been much visitation, I can't do the expanded standard. We do, we can do a variety of things on visitation, but expanded standard is kind of like from Thursday night to Monday morning. And then standard visit is Friday night to Sunday night. I think the situation right now is not appropriate for us to do expanded standard. Put your hand down and listen. Right now, based on what we've had so far, I think it needs to be just Friday to Sunday night. But I do want to explain the expanded standard. Sometimes that may work better. It can help with exchanges as well. Like I said, regular standard is Friday at 6 until Sunday at 6. Expanded standard, sometimes what do you have when you have the regular standard visit? Mr. Norris has the right to visit every Thursday night from 6 to 8 every week, even if it's not a visitation weekend. That might be a good opportunity to start off some visits, maybe shorter visits, if that's what we're looking at, since that may be, but this is a visitation weekend as well, since it's going to be the first weekend of June. I'll leave it up to y'all if y'all want to do that. Maybe a transition is something y'all should talk about. I don't know. I'm not going to order it today. I want father to be able to visit. I think Mr. Norris is really excited to go visit. I cannot enforce Mr. Norris to visit. If he doesn't visit regularly, that's up to him. It's his choice. But I'm hoping that Mr. Norris wants to visit. And so if y'all want to do just a couple hours this week and a couple hours next week, and then go from there to the weekends, that would be reasonable. That's something I'm gonna leave for y'all to talk about after court today, if that's what you want to do. But if Mr. Norris says, if y'all don't have an agreement, and Mr. Norris says I want to do my Thursday night and my visitation weekend, then I'm not stopping him from doing that. We also can't let the 4-year-old decide what we want to do, because they're not obviously adults, and they're obviously gonna. This 4-year-old is probably gonna not be too happy at first, but that doesn't mean that's a reason for us to deny visitation either. It's going to be a little hard at the beginning, but they'll get over it the more that Mr. Norris visits, the more often and more regular that it is. So the expanded standard is like where y'all, Mr. Norris, instead of having the Thursday night visit, would pick up from school on Thursday afternoon and take the child back to school on Monday morning. That's something that maybe later down the road y'all can do, maybe by August. If things have improved a lot, maybe that's something y'all want to do. I'm not ordering that today, but just trying to give you kind of an idea of what expanded standard is like. If that's something y'all want to agree to later on, whenever it may be, that's kind of what we do as expanded standard. But for now, I'm just ordering the standard visit, which is just a Friday night to Sunday night. Let's start off there, and then go from there. Exchanges at mother's residence. If y'all want to mutually agree to some other location, you can. I'm not putting it in the court order. I do have concerns, of course, that Mr. Norris would show up to an exchange location and Ms. Hamilton, you would not show up. So we don't want that to be a problem. That sounds like I said that things have improved a little. Maybe the past issues you've had are gone. So I'm hoping that we can just do a exchange at residences. But if y'all need to meet somewhere, you can talk about that as well. So usually we pick like a restaurant, a fast food place, or a store nearby where the mother lives, if that's something y'all need to do in the future. And that protects both of you, so that way there won't be any allegations of domestic violence or things like that, because hopefully other people will be around. That usually will help to kind of limit those situations. But I'm just doing exchanges at mother's residence in the court order. Court calls billed to Mr. Norris. All right, the Attorney General's office is going to put that all in writing, and for me to sign, and then they will be emailing you a copy of that. You need to follow the court orders. If you don't have an agreement, follow the court orders. If y'all have a side agreement, you can do that, except for the child support. The child support you must pay through the child support office. But besides the visitation and things like those details of those kind of things, y'all can definitely agree to those differently. But I explained to people, even though it sounds kind of silly, that it's two people agreeing, not one person telling the other person what we're going to do. It takes two people to agree to it. So if two of y'all agree and y'all want to kind of modify the visits, then definitely that's something that I would want y'all to work out. But from where we are right now, even though we might be enthusiastic about visitation, we need to probably just stick to the every other weekend visitation for now until we get things improved. All right. Hopefully that resolved your situations and hopefully this will make things a little easier. You do have to follow my court orders, even if you don't agree with them. You had a question, Ms. Hamilton?
I did. Excuse me. I did. I just wanted to make sure. So for the visitation, I know the Friday, Sunday pickup here. Can he start his visitation this Thursday? Did you have Thursday still in there, or was it
it's
just
every
Friday
Thursday.
to Sunday? And that can start this week, right? 6 to 8.
Yeah, that's what I was encouraging you to do. At the very least,
Okay.
that he do the Thursday from 6 to 8. And
Mhm.
then the next day will be the first weekend of the month. So the first week of the month, he has Friday to Sunday. So he'll get a little extra visitation this weekend, unless y'all want to just skip the visitation weekend and just do the Thursdays, maybe for a couple weeks, and then jump to the every weekend. That's something y'all gonna have to talk about after y'all cool off from court today, as far as that's concerned. But if you don't have an agreement, we don't work anything out, then yes, he visits Thursday night from 6 to 8, unsupervised. And then he comes back on Friday night at 6 for the weekend.
Yes, sir.
Okay. Mr. Norris, did you have any questions before I let y'all leave?
Oh, I was just asking about just a proactive as far as you answer the question, just to help True's transition. I haven't seen him since last June, and so therefore I just want to make sure it's a smooth transition. I moved to Princeton and updated my address as of recently living here, but I wanted to make sure that it's effective for True. So she lives in Dallas. I live in Princeton. So you understand, I don't mind making the drive, but you understand what I'm saying? I just want to make sure that he's going to bed on time, you know what I mean, and all that good stuff. So I'm willing to work with that. Just want to kind of be on the same page as far as address. I'm not in Allen anymore. I'm in Princeton.
I don't know where Princeton is, to be honest with you. So how far away is that
Yeah.
from Dallas?
Well, it's about 45-minute drive, and so it's one of the fastest growing cities in the U.S. right now. So just from traffic, just consideration for her. I will work it out. I just want to throw that out there. I did change my address within the last couple of weeks. It is on the system. I just want to make sure that we have a good place to meet that helps Miss Hamilton and also is effective for True and myself.
Yeah, I mean, within reason, it makes sense. I mean, sometimes people don't get off of work until 6, so they're not going to
Right.
be there for the visitation periods, or in your case,
Right.
maybe you have to go through a lot of traffic to get to Dallas. So
That's
that's
not
where
a big
you
deal.
communicate with each other and say, hey, I can't be there Friday at 6. It's just not going to happen, even though I want to be there, but I can be there at 7. That's
Right.
reasonable. That's a reasonable request. That's where you tell Miss Hamilton. Miss Hamilton doesn't know your schedule. She doesn't drive
Right.
from Princeton to Dallas, so she doesn't know. So that's
Right.
something y'all can talk about and say, hey, I need this a little bit of adjustment here. I don't want to
Right.
lose my visitation, but I need to
Right.
adjust it a little so that it can make sense for everybody, and I don't want to be late.
Okay, co-parenting isn't supposed to feel like a competition, but after a bad breakup, that's what it turns into. It's crazy how a simple, hey, I'm running late, can suddenly feel like a disrespect when there are still hot feelings. Hopefully, they can put their pride aside, act matured, and just communicate well for the sake of their kids.
So that's little details, like I said, that y'all can work out and communicate with each other better about. All right, then we'll sign. They're going to submit an order to sign. They will email you a copy. Y'all are done with court. You can press leave on the Zoom to exit out.
Thank you.
These cases keep on getting messier and complicated. You need to watch Mr. Williams fight to reconnect with their daughter after years of absence, only for the mother to demand supervised visits, despite admitting he has never harmed their child.